We lost you for a moment. No, can you hear us?
Yes, it's better now. I can hear you now.
Yes. Please go ahead.
Yes, so I'm saying that an appeal is by way of rehearing, and so the matter is more or less going to be reheard. That's what you should know. And so, to that extent, you do not want to constitute yourself into a court to be giving full attention to the matter and more or less making some determinations even before the conclusion of the case. But we are to that extent, even though you may have one or two things to share, you will not be able to dive deeply into the matters. But what I'm saying is that I've looked at the grounds of appeal, and I note that one relates to the convictions, and for that matter, the sentencing, where the argument was made that the conviction was unreasonable, and therefore there wasn't enough or sufficient evidence to support that conviction. And then the second one that I also saw relates to some relevant provisions of the Mining and Mineral Act or Mineral and Mining Act, saying that those provisions were not clearly either understood or properly read by the judge, and that if she did, she would have actually reached a different conclusion, which means that those provisions, they appear to be exculpatory of the accusees, first and then the third accused persons, and therefore they appear to be largely inconsistent or consistent with their innocence, if you like. And then the third one also deals or relates to the fact that the trial judge usurped the jurisdiction of the Supreme Court in interpreting some relevant provisions vis-a-vis the Constitution, and specifically Article 19. And so there are some confusions, in my view, in some of these grounds ways. But like I said, because the matter is not properly, once it's been filed, it's not properly before the Court of Appeal. And so you do not want to dive into the details of that. But I, just by way of a brief comment, I sincerely do not see any outcome entirely different from what the trial judge has come out with. Because in my estimated view, the trial judge did a fantastic job, especially because in the absence of direct evidence, the circumstantial evidence is as good as that, to the extent that every ingredient of the offense that you seek to prove or you seek to evaluate, having regard to the arguments in terms of the cross-examinations, re-examinations, and even the evidence in chief of the accused persons, you want to put all those in context as far as circumstantial evidence is concerned. And having regard to all this, there can only be one conclusion, which conclusion is irresistible, and that such conclusion is that the accused person is guilty. You see, and so it is a case, and if once you take a critical look at the analysis done by the trial judge, you will observe that she did due diligence, a very diligent job. And so, like I said, it's going to be a difficult thing for somebody to make an argument outside what was made there anyway, because she took into account the evidence from that of the defense counsel, that of the prosecution, did thorough analysis. Because it's circumstantial evidence, you actually need to go even a bit further to do thorough analysis and then establish that indeed all the circumstances that you have gathered, the pieces of evidence, when you put all strands of evidence, when you put all together, they can only lead to one irresistible conclusion, as we say, which conclusion must be inconsistent with the innocence of the accused. And that's clearly what I see the learned trial judge actually did.
Mm.
And so, I mean, we
Interesting.
leave that to the Court of Appeal to also have a bite on that.
You called it a rehearing, so which means you are putting all the evidence and everything you put before the High Court and telling the Court of Appeal, examine it and agree with me.
Yes, I mean, so they will look at all that because you have put all your evidence before the trial court, and she looked at all the evidence. She will have to even evaluate them, see those evidence that are even admissible, whether some can be accepted by the court, and even when they are accepted, what value will be placed on them. You know, that's what we call probative value. You know, what does it add to it? Is it relevant anyway? How does it connect to what we are looking for? Because if we are looking for dogs, and then you go and bring a cat, you know, well, it has four legs anyway, but is that what we are looking at? But if you are looking for dogs, and you go and bring a local dog, somebody brings a foreign one and all that, it's still a dog, except that the breeds differ. But a cat is not a breed of dogs or a dog. Do you understand the point I'm making? And so that's how evidence is. You can choose, you can bring any evidence, but the point is its admissibility, whether it will be admissible. And when even if it is admissible, the value that will be placed on that is another matter. Do you give it the needed attention in evaluating your facts? You have a regard to the law. And so all that will play out. Now, the caution must also be noted that once an appeal is a way of rehearing, we may not necessarily be able to introduce new evidence into the matter except under some limited circumstances, such as the case that at the time of the matter before the trial court, it was practically impossible to have discovered that evidence. Do you understand? Or you could not have procured it. I mean, some limited circumstances like that. And so it's not to suggest that we may not be able to introduce new evidence or new evidence may not be admissible. But the point is that you must demonstrate that at the trial court you could not, or it was not within your reach, and that every diligent effort made at the time could not have actually discovered that. And so when you are able to establish that, then the Court of Appeal most likely will oblige you to bring it in the interest of what? Justice, because it is there to administer justice and not just mere administering justice, but administering it in a manner that it reflects fairness on the part of all parties or both parties, where we are dealing with two parties. And so that is where we are.
I see. Let me then conclude with you by asking you, because we saw two terminologies that were used in the grounds of appeal. The other ones, they talk about constitutional error and an error of law. What's the difference between the two when you say a legal error and a constitutional error?
A legal error could be any form of error relating to a position of law. And so if the law says that you add A plus B and the answer should be C, and then you now add A plus B and guess a D, that becomes a legal error. But where we are dealing with a constitutional error, it means that where a constitution has provided for a particular act or step to be taken, and you fail to take that step in dealing with a certain provision of that constitution, or the constitution for that matter, then we are dealing with a constitutional error. And so in simple terms, that's the main distinction. So one is exclusively to the constitution. And you know the constitution, when you are dealing with the constitution, it's a unique document and it's a supreme law of the land. And so dealing with it comes with a certain authority, which authority has no parallelity. But a legal error could be in the context of any space, not necessarily relating to the constitution. And so it could be in terms of a position of a law or a principle. And so that's the way you should look at it. I mean, in basic language, so that you don't get any form of confusion.
Thank you.
I note that in their reference to the usurpation of the jurisdiction of the Supreme Court by the judge, relates to a claim that they have a certain understanding of some provisions of the Minerals and Miners Act, and because they have a certain understanding, which relates to how Article 19 should be applied, whether an offense has been established, and if established, whether there's a corresponding penalty or punishment for same. There should be a prescribed law, which law must have a consequence also prescribed by law, that is in a written law. And so that's the angle they are coming up. And like I said, because I do not want to dive into it, it's something they are just raising just to excite the argument. Otherwise, I'm sure the trial judge has dealt exclusively with all those matters, and it leaves no ambiguity whatsoever, no constitutional interpretation whatsoever in her view, and which I agree with her in a way. But like I said, I mean, every lawyer wants to demonstrate to your client that indeed you fought a very good battle, except that the battle was just way beyond your means or your ability to overcome. And so that's exactly what they are doing. And of course, remember, this relates to a political party's chairman, which chairman has also done some good to some members of their party who may happen to be lawyers. And so, in an attempt to let them see their appreciation for all that he may have done for them, they are taking the matters up and just to, by way of their solidarity, and not necessarily because of some solid legal grounds for which reason all these things are coming up. That's the way you should also look at it. Because if you look at some of the arguments being made, even on televisions, the radio stations, and all that, you notice that no, these are not proper legal matters being raised.
Okay.
To the extent that some are even questioning the judge's authority or even ability to use circumstantial evidence under the circumstances. Indeed, I have heard a lawyer asking for the first time that this is the first time circumstantial evidence has been used. I don't know where that position is coming from. If the person actually was minded to have read their evidence, I mean, first year in the law school, and those who have even done evidence in the faculty, you would have come across some notorious cases like Ali Kasna and all, a number of them, dating back from 60s, coming 70s, and all that. And so, like I said, it's so shocking that you hear some of this commentary. If a lawyer can say the substantial evidence was used for the first time in this case, then we have a serious issue at hand. And I think that you, the media men, doing fantastic work, you have a responsibility to give the public the opportunity to be educated on some of these matters so that it doesn't mislead them as though something untoward is happening within our legal space.
In
That's a
fact,
very
in the case of this appeal, the word that was even used is assumptions.
Yes, so that's the point I'm making. You
Mm.
see, even in the Evidence Act, we have what we call presumptions, and presumptions they span throughout the Evidence Act, and you will find around in fact a number of areas, Evidence Act itself. So it tells you that the law itself is a product of assumptions because you must assume and then try to disprove the assumption. And grounded even in the 1992 Constitution, it is a cardinal assumption of the innocence of every accused person. Have you updated your mind to that? That when someone is arrested, you should presume that the person is innocent. Is that not an assumption? If you don't do that, how then will you be able to be the person fair hearing? And how then does the prosecution prove their case against the accused person? So those I want to believe are not legal arguments. They may be political arguments or some other commentaries outside a legal context. If we want to go into those areas, we'll be doing so much disservice to the people because we are now beginning to say that people are using their own impressions to deal with matters when clear and obvious provisions of law have been made available to support all these things. Except that in doing that, that's why there are principles also governing your application of such presumptions. The presumption of innocence, to the extent that the underlying principle about it is that the person must be presumed innocent, and therefore the one claimed that he has offended must prove the offense the person has actually committed. And cardinal to this presumption of innocence is to the extent that the accused persons, when arrested, they have every right to remain silent in order to avoid making a statement that will seek to incriminate them, to give them out for prosecution. That is a very sound presumption. Is it not an assumption? Yes. So again, when they say a person, if you marry and for 7 years or even more, you don't see your partner, you haven't heard from the partner, you should take it that the law has actually indicated that the person should be presumed dead. What about that? Your evidence is dead. So I'm just walking you through statutory provisions, giving justifications to some of these presumptions. So they are not the imaginations of the judge's own actions. No. So let no one sometimes mislead the innocent and unsuspecting public by making some of these comments. They do not help.
Okay.
We should be educating people on clear provisions of the law and try to explain the rationale for such presumptions.
Okay. La, thank you.